Okay, it's all yours.
Thank you so much, Gary. And nice to see all of you and some friendly faces that I recognize. As Gary mentioned, I'll tell you briefly about Bean Kinney and Corman. We are a law firm based here in Arlington. We've been here for more than 60 years, so I believe we're the oldest firm in Arlington. We do all sorts of different things. Obviously estate planning, but lots of small business, general corporate matters, litigation, domestic relations, land use. So any legal needs you have, feel free to reach out to me or to Chris Richardson, who's on and also participates in a lot of A&V events, I believe. With that, I'm going to start the estate planning presentation. And so what I should say is, as Gary said, feel free to post your questions during my presentation. I'll leave plenty of time at the end to try and answer any questions. Some questions, however, if they're sort of very person specific, I may say, let's chat offline or whatever, and I'm happy to have a conversation separate from this for you. So I'm going to share my slides for you. And here we go. So estate planning, a lot of you may have estate planning documents, but sort of brief overview, we consider power of attorney, advanced medical directive, or healthcare directive, will, and trust to be sort of basic estate planning. Now, not everybody needs all of those documents, but when we have sort of an initial consult, those are what I run through, and then we have a discussion about it. I'll go through a few other things that relate to estate planning as well, such as titling of property, gifting, life insurance, things like that, because I consider all of those related to your estate plan, and we want to make sure you have everything in place that you need and to set your family up so life is as simple as possible. So a general durable power of attorney. You may have separately executed a limited power of attorney. For example, when you bought your house, I'm positive you executed a limited power of attorney for the title company to make minor changes, if there's a scrivener's error or something like that. This is slightly different in that it is general, meaning it covers everything. So whoever you are granting this power to can step into your shoes and act as if they are you. Contacting financial institutions, filing tax returns, things like that. Durable means it continues from the moment you sign through incapacity and inability. The only time it terminates is if you die or if you revoke it. Now, there's something known as a springing general durable power of attorney, which means as opposed to it being effective immediately, it is effective when two medical professionals deem you unable to act. We can have a whole conversation separately about which one is more beneficial. Certain ones make sense, certain people have different concerns, but I just want to make sure you're aware of those differences. I strongly recommend everybody have a power of attorney in place because it avoids a guardianship proceeding. Guardianship proceedings are, for lack of a better term, miserable for both the person going through it, the family member that's trying to get a guardianship over them, because essentially what a guardianship would have to do is go to court, have a guardian ad litem appointed who would go and interview the person who a guardian would be created over, as well as get medical records, notes to figure out really are they incapacitated or is there something else that needs to be done. Again, power of attorney just makes it more simple. The requirements in a power of attorney differ from state to state. So if, for example, you created estate planning documents in California 20 years ago, you probably want to look back at them, have an attorney here in Virginia look at them to make sure they still are active and comply with the laws here in Virginia. So related to a general durable power of attorney, but a separate document, is an advanced healthcare directive or living will or medical power of attorney. This names who can make medical decisions for you. Again, generally it's in the event you're unable to do so yourself, but it can also be effective immediately. When my grandmother was kind of losing her faculties, but not totally, she gave this to us so we could sort of sit along with her and make decisions as she did and be in the total loop about everything. This establishes your individual preferences, never a feeding tube, yes, organ donation, yes, pain management, never hospice, sort of whatever you want in those end stage conditions are what you want to put in here. What I should say is you definitely want to have this in place because otherwise you are most likely to be kept alive as long as humanly possible because medical institutions don't want to be sued for wrongful death. So if you have strong feelings, make sure you have this document in place. So the power of attorney and advance directive, you are in place again while you're alive. The moment you die, they die with you. But again, these are the ones that you may be most concerned about because I have a lot of clients that say to me, well, once I'm dead, and I don't really care what happens. That's fine. But you do care while you're alive. So the next document I'm going to go to is related to your will and titling of property and what happens to your assets. So the titling of property overrides whatever your will may say. I had a client come to me earlier this week. She owns her house, joint tenants with rights to survivorship with one daughter. She said, well, gosh, I want to change that so that when my home gets sold once I die, it gets split equally among my 3 daughters. I said, well, we have to change the title of your property. Similarly, people create bank accounts jointly with one child. It technically just goes to that one child at death. So it's an important time as you're thinking about your estate planning to think about, do you hold the title to property how you want it to be held? Similarly, the designated beneficiary on assets, for example, retirement accounts, life insurance, that's going to override whatever your will may say. So some people may have had, for example, we have a client who died recently and she had her cousin still listed as the designated beneficiary on a whole bunch of certificates of deposits. Well, the cousin had died 10 years ago. The cousin's daughter even died. So we went down a whole rabbit hole trying to find who these went to. So again, you want to look at those designations to make sure they are what you want them to be. I'm positive that her intent was not for it to go to this grandchild of her cousin's daughter who she never even met, but she never updated it. So that's where we are. Wills. This is the document that comes into place when you die. It is effective immediately at your death. So whoever your executor is, they're the ones that technically have the authority to make your funeral, burial, and other arrangements. Now, you see the movies and movies all have reading of the wills, right? You go sit down in a lawyer's office, have the will read out loud. That doesn't actually exist, particularly with this funeral and other arrangements, burial, things like that. Typically, most people have to act pretty quickly after death to set all of this up. No one may read your will until after all that happens. So you want to make sure everybody knows what your wishes are as related to that issue so that it's continuous and known what you want to have happen. Then when we get into the will, you can make specific bequests. Lots of people leave, 20% to 4 different charities and then 20% to these 5 nieces and nephews or all sorts of various things. But this is where you would list out how you want your assets divvied. The executor is the person who takes the assets from you and ultimately distributes them out to your beneficiaries. They have responsible for paying your last funeral, burial, illness, filing your last tax returns, all that good stuff. So, one of my colleagues jokes, you probably don't want to appoint as an executor an artist, a musician, sort of someone that's not of the mindset of keeping good expenses, keeping everything, being really, really detail oriented. In the will, not that it applies to you all, but you can appoint a guardian for minor children. So if you're talking to your children, they probably should have this for their children. If you die without a will, that is known as dying intestate. In Virginia, what that means is essentially if you're married, everything goes to your spouse. If you're not married, everything goes to your parents. If your parents are deceased, to your siblings. If your siblings are deceased, to their children, and so on and so forth until it finds someone. So I've been in estates where it's gone to 5th, 6th, 7th cousins because they never had a will, and we have to go and do an air search to find them. So if you do know where you want your assets to go, or if you know you don't want them to go to a certain person, update your estate planning documents or make sure you have something in place. Right, one of my clients this week, he told me he's having surgery on Friday. He knew exactly what he wanted for his power of attorney and advance directive. And he said, well, I'm just not going to do a will because I don't care. And I said, are you sure? Because you just told me you absolutely hate your brother, Michael. And if you die in surgery, not to be morbid, your 3 brothers are going to share everything equal. So at a minimum, because he was concerned about what charities get what amount of money, I was like, at a minimum, you want to write a will to say, I disinherit Michael, and then let everything go to the other 3 and then figure it out. But I was like, if you're so adamant, you do need to put this in place because otherwise your all 3 brothers would inherit equally. So trusts, I'm not going to go too far into detail in trusts because there's so many different kinds. Trusts are a great tool when appropriate, but they also overly complicate estate planning sometimes. The main reason people create trusts are for a couple different reasons. The first and foremost is to avoid probate. I have lots of clients that come to me and say, oh my gosh, I just went through probate in New York for Aunt Sue. Never again do I want to have anyone have to do that. Great. A trust avoids probate entirely, and it goes outside of the probate process, and we transfer your assets into that trust. However, one of my biggest pet peeves of my clients is when you create the trust, but don't transfer any assets into it. Because then here in Virginia, you have to go through the probate process to get the assets into the trust, and then you have to go through the trust administration to ultimately get them to the beneficiaries. So if in the past you've created a trust and haven't put your assets in it, let's work on doing that so that you're not creating double the work for everyone. So a couple different types of trusts. The first kind is the testamentary. This is established in your will. In this type, it does not avoid probate, and there's a yearly accounting requirement. So I really discourage this type of trust. But where I often see people wanting to create these is, for example, they are leaving their assets to 3 grandchildren who right now are 19, 20, and 21. And they want their assets to go to them, but not until they're 23. This is sort of a good stopgap measure so that they don't inherit them outright immediately, but it's not a huge burden because as long as they make it 3 more years, they're good. So inter vivos or living trust or revocable trust, this is what you most likely want. There are many different kinds of this, but when you come to me saying, I want a trust or I have a trust, you have one of these. So it's established during your life. It can be revocable or irrevocable. Irrevocable means once you create it, it is done and it is set and you cannot change it. The main reason people create irrevocable is for tax planning purposes. So I like to have sort of a long, detailed conversation with people about why they think that's what they need and actually determine if that's correct. Revocable, right, is perfect. It means you can change it at any point in time for any reason, as long as you're mentally competent. So that's much easier, and that's the typical type we create. A couple different types beyond that are an irrevocable life insurance trust or an ILIT. These were very in vogue probably 10 years ago. So you may have one. You can't change it, but you can easily revoke it, for lack of a better term, because you simply change the life insurance policy. They're bypass trusts, which are for credit shelter reasons, qualified terminal interest property trusts. These are typically related to if you have a spouse that's not a U.S. citizen. Personal residence trust, these are not typical in Virginia, but it would be putting your house into a trust, most likely to help with avoiding the state level estate tax. Charitable trusts and grandchildren/kiddie trusts. So these people do create, there are many different options for creating accounts, trusts for children and grandchildren. But creating a trust or creating an account is a good way to get assets down to the next generations while you're alive. So estate tax, you probably have read lots and lots and lots about the federal estate tax. It is super confusing. The first thing I'm going to say is the good news is by living in Virginia, Virginia has no state level estate tax. Maryland does, DC does, about 13 other states do, but Virginia doesn't. So all we have to worry about here is the federal estate tax exemption. Currently, it sits at $13.6 million per person. It's portable, meaning your spouse inherits your interest, you inherit your spouse's. So really it's 27.2. In 2026, so January 1, 2026, about 18 months from now, the federal estate tax is going to come plummeting somewhere between 5 million and 7 million unless Congress acts. So I have lots of clients coming to me trying to figure out what they need to do because they're in that 5 to 7 range. Obviously not all the way up to the 13.6 range, but we do have tools we can use. But the current tax rate for this is 40%. So every penny currently above 13.61 and every penny above 5 to 7 million in 26 gets taxed at that 40% rate. So it is important if you are close to any of those to think about what you can do to minimize that tax bill. And the assets that get added in here are everything. Your life insurance, your primary residence, any secondary homes, bank accounts, IRAs, right? So a lot of people here in Arlington, particularly, when they add up their life insurance, the primary residence, and whatever retirement they have, come bumping up close to it. So it's something we just have to think about and sort of try to start planning for. Portability. I just chatted about this, but again, it's your spouse inherits yours, you inherit your spouse's. We don't have to do anything different. Certain states, if you're thinking about moving, let's have a chat about if you're going to move to DC, because DC has no portability. So you're stuck with just your exemption. This is a map that'll show you the states that have estate taxes, the states that have inheritance taxes, and the states with both. The inheritance tax relates to if you're leaving things to people outside of your direct lineage, so your children, your siblings. And what trips people up is, for example, jewelry. If you are leaving jewelry to someone in Pennsylvania, a friend, they technically are stuck paying taxes on the value of that jewelry if you leave it in your will. You are better off gifting it ahead of time. Now, the good news for you, if you as a Virginia resident do that, no tax is going to apply, even if the person lives in Pennsylvania. But if you move to Pennsylvania or you receive an inheritance from someone who's a Pennsylvania resident, know that this is potentially coming. As I mentioned, certain states have separate estate taxes. Maryland's is at 5 million, DC is at 4.7 million. So if you intend to die a resident of one of those, my strong suggestion initially, just die a resident of Virginia. But we can also have a longer conversation about why or how you can get around those. Inheritance tax. This is what I just mentioned about jewelry, things like that. And again, we're not concerned about this in Virginia, but I sort of put a pin in it for you because you may have friends in these other states, or you may be contemplating moving there one day. Federal gift tax. So this is the greatest misnomer in this sort of area of law. When you make a gift to someone, there is no tax due. Where the gift tax comes in is each year, currently it's at $18,000 per person per year. So you could gift to your son, your daughter, and each of your grandchildren $18,000 per year without having to file any sort of federal gift tax return, without having to pay any taxes. And no, they don't have to pay taxes either on that, receiving that $18,000. If you go over that $18,000, so let's say you gift $100,000, what happens is you have to file a federal gift tax return. It's not a very complicated form, but you have to file it with your federal tax returns each year. Then that $100,000 gift tax reduces down your overall federal estate tax. And so the question someone asked is, do inheritance taxes apply to insurance beneficiaries who are out of Virginia? No, if you are a Virginia resident when you die and leave these things to them, it does not apply. It may apply if they live in Pennsylvania and leave you as the beneficiary on an insurance policy. That's where it may apply. I'll come back and answer the next question, the first question in a second. So again, the federal gift tax is really not a huge deal unless you're going to be gifting $13 million, which fabulous, but let's come up with a plan for you. And this is where we talk about gifting strategies. There are ways to do gifting that's going to help decrease your overall estate at the end and sort of get money down and out to other people. There's something known as Uniform Gift to Minors Act, Uniform Transfers to Minors Act. Those are accounts that you can create for minors where you're a co-owner of it until they reach, I think it's 21 here in Virginia. But it's a way to create an account for them, put $18,000 in there a year, and it creates a nice little nest egg. Charitable giving, things like that, medical expenses, all will reduce out of your estate and make it easier, and potentially don't even count against this gift tax. So the Secure Act. I'm not going to go into great detail on this. I'm happy to chat with you about it. This is a law that keeps changing and evolving over time. But it relates to your IRA, 401k, 403b, any taxable retirement account. So it does not relate to your Roth IRA. But spouses can inherit your retirement account and have as long as they want to take the benefits, the money out of those accounts. Anyone besides a spouse and an individual with a disability only has 10 years to pull out your retirement funds. And why that's important is that potentially causes a income tax burden to them because these are taxable accounts. Now, what I always remind people when they start freaking out about this is sort of found money in that if you left them $100,000 in your retirement account, well, this was $100,000 they never had before, so if they have to pay taxes, fine. But there are strategies around these accounts related to trusts and things that people potentially want to consider just in case you are concerned about that, or if you're leaving these to your children and you may bump them into a higher income tax bracket. So there are things we can do with that. But again, these are your taxable retirement accounts. And it's important, just as you're thinking about who's going to inherit what, what burden this may create on them. Spousal rights. So this is an interesting topic that, again, I won't delve too far into, but the short version is, in Virginia, you cannot disinherit your spouse entirely. Now, back that up. What that means is you potentially can disinherit your spouse, but your spouse can make an elective share claim for up to 50% of your marital assets, depending on how long you've been married. And so where this gets funky is particularly second marriages where there are children from the first relationship, then there's the second relationship. The person tries to disinherit their spouse, and the spouse says, no, 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 I've been part of this marriage for 15 years. I deserve 50%. So they then make a claim against the children from the prior relationship, and it gets really messy really quickly. If you're thinking about doing this, let's chat, because again, this is a hard thing to deal with, and Virginia's laws on it are very unique, let's say. All right. So when to review your estate planning documents, because a lot of you may already have documents in place. If you do, look back at them. First rule of thumb, every 5 years. The other is in the event of a major life circumstance change. So that means if you get a large inheritance, change jobs, change states, have the birth of a child, marriage, divorce, death, sort of anything like that, just look at it. It does not mean you need to update it. It just means you want to make sure your documents match what life looks like now. Another reason is tax law changes, and that's what I was just alluding to about potentially the federal estate tax is going to change drastically January 1, 2026. And someone asked a question, what does the federal estate tax effect have if you're the beneficiary of a trust? And do you still need to pay taxes on everything over 7 million? So the short answer to that question is it really depends what you are inheriting and how you're inheriting it. I'm hopeful that person's trust is set up that the funds are used to pay taxes first, and then you receive your inheritance. So you personally likely have no tax burden, but I don't know what that trust says. Again, beneficiaries aren't taxed necessarily. It's that trust or that estate before it gets distributed out that gets taxed. So that concludes my PowerPoint presentation, but I'm definitely happy to answer questions, do anything like that. I'm going to go back because a couple people had to ask questions sort of as I was moving through. One of the questions is, in Virginia, what is involved in transferring assets into a trust? Do banks have to be notified? So the short answer is we can prepare deeds to transfer your real property into your trust. Otherwise, at financial institutions, yes, you need to contact them to change the owner on your account to be your trust. The other way to do it is to change the designated beneficiary on your account to be your trust. And depending on the financial institution, one way is typically easier than the other. So, again, feel free to reach out with questions, anything else that you have. We're here. I answer questions for people all the time. I will put my contact information in to the chat. I also will share my PowerPoint presentation, and Gary, Cheryl, whoever can share it with everyone so that you have it. You can also find me online, but sort of how we operate is I have an initial free consult, 15, 20 minutes just to learn a little bit more about you, figure out what we potentially need to do. Lots of people come to me asking, hey, I have these existing documents. Can you review them for me? Absolutely. I'm always happy to review your documents. I just typically charge my hourly rate. And then we can figure out whether you even need to do anything. The other question that people often ask me is, gosh, my children haven't done this. Can I and my children do this and have a conversation? Obviously, we have to get waivers of conflicts, things like that. But yes, we can help make sure everything's in place. Because, for example, my mother-in-law was concerned what burdens would be placed on her being named guardian, named trustee, things like that for our documents. So this is a good way to make sure everybody is in the loop and knows what they're doing. So one question I see is, I mentioned info on Maryland, Virginia, DC. Do I do a state law in Delaware? So we regularly prepare deeds to transfer beach houses in Rehoboth, Bethany, whatever, into trusts. But I am not barred in Delaware, nor do I pretend to be, and the laws differ from state to state. I practice Maryland, Virginia, DC. I'm happy to give you a referral to an attorney in Delaware with whom I've worked many times. The federal estate law changes will come into effect January 1, 2026, unless Congress acts. We anticipate, if I had a crystal ball, something will happen after the election in the next year, so we don't fall off a cliff and go all the way back to what the laws were 8 years ago. But again, no one knows, and if you had a crystal ball and knew, you'd be a very wealthy person. Someone asked, do I have to remove my husband from title of my condo since he's died? Will it complicate my will if I've not done this? No, you don't need to. Assuming your property was owned, joint tenants' rights to survivorship, or tenants by the entirety, you automatically inherit it, and all that'll happen when you die or when you go to sell it is someone will ask for a copy of your husband's death certificate and yours, and then that would get it done easily. So no, you don't have to, but what I would say is if you're changing the titling on your condo anyways, for example, to put it into a trust, you would want to update it then. And we do that easily for people sort of in one fell swoop. Someone asked, can we just do a will without all of the other documents? Absolutely. You can pick and choose whichever of the documents you want to. I strongly, strongly, strongly urge to make sure you have a power of attorney and an advanced medical directive in place too. You don't have to do them with me. There are forms online, but those are important to make sure someone is authorized to make decisions for you. But yes, we absolutely just do a will. I just did that for a client of mine 3 days ago, because she was concerned from Ernesto that's coming, and she was going to the Caribbean, and she was like, I just need a will to make sure my assets go to my friend Lydia. I said, fine, no problem. We can do a will, and it was a really simple will. Again, if you're getting more complicated in terms of leaving a ton of assets to a ton of different charities, or your asset picture in general is complicated, I might say we need more. But I definitely, and our firm definitely, does not say, oh my gosh, everybody has to have a trust, power of attorney, advanced directive will. Oftentimes, I frankly talk people out of trusts who come to me saying I need a trust simply because it's not necessary and could overly complicate their estate outside of what they thought they needed. So a few other things I will touch on. Again, to go back to the gifting point, you are welcome to gift whatever amount you want to someone. Just remember that if you go over that $18,000, you need to file a gift tax return. But again, you are not going to owe any tax related to that. And no one will ever owe any tax related to that unless your estate exceeds the $13.1 million number. Then that becomes a problem. So sort of just think about that. Someone asked, do you handle leaving assets to people outside the US? Kind of is the short answer. I don't know what the laws are in other countries regarding inheritances. For example, if you're leaving your assets to someone who's a French citizen, France has all sorts of taxes that apply to it. And that's potentially something they need to work with a French attorney to deal with. But absolutely, we can set up documents to leave assets to those people and make things as simple as possible. Someone asked, which is better, to put the real estate into a trust or do a transfer on death deed? So a transfer on death deed is a unique thing to Virginia and about 16 or 17 other states. Just like on a bank account, it enables you to designate a beneficiary. So I have lots of people say, I'm leaving my condo to my 3 children and record the transfer on death deed. Then all your children have to do is record your death certificate, and they will own that condo outright. The main reason you may not want to do that, if you have 3 children, for example, and would rather leave it in a trust, is so that there's one person in control. If you think your 3 children are going to be fighting like cats and dogs over control, it's easier to leave it in your will or leave it in your trust so that you name an executor, name a trustee, who then will have control to make that decision. That's definitely sort of the best way to go. Related to that, someone asked, if you add someone to a property deed, do you need to file a gift tax form? The short answer is yes, most likely. Longer answer is, I strongly discourage you adding someone to your deed. Because, for example, let's say you bought your condo for $50,000. It's now worth $550,000. If that person inherits your condo, no one pays capital gains taxes on that big difference. There's something known as a step up in basis. So that person who inherited your condo would now get basis of $550,000. Versus if you added them to your title now, yes, potentially you have gift tax filing requirements, but also their basis is going to revert back to your $50,000. You don't want to do that unless there's a strong reason to add them. There are other ways to do that. Someone asked, am I a solo practitioner or do you work for a law firm? So I'll give the pitch again for Bean Kinney. I work for a firm. We've been here in Arlington for more than 60 years. We practice in a large array of areas of law. I and a bunch of my colleagues do estate planning, estate administration, trust administration. We also handle all sorts of different things, land use, zoning, litigation, small businesses, general corporate, employment. If you ever think you need a lawyer, we are happy to help you or provide you a referral to someone who can help, or if you know someone who needs it, we're happy to. Chris Richardson, who I think is active in your group, works here as well. She's our head of marketing and does a great job getting our name out everywhere. And, again, we're happy to help with that. So someone asked, does paying a family member's tuition fall under the gift tax? That is an excellent question. And the short answer is yes, technically, but I believe if you chat with an accountant, there may be an exemption for payment of education, similar to payment of healthcare expenses. You just want to check on that. In addition, technically putting money into a 529 plan is a gift to someone. But I think most accountants may say, unless you're exceeding that gift tax maximum by a lot, you may not need to file a gift tax return. Again, some of these tax questions, relate between accountants and lawyers a lot. I know enough tax to be dangerous, but not enough tax that you want to rely on me. I have lots of accountants here in Arlington that I work with regularly and refer people to and are happy to do that. Someone asked, how are fees determined to prepare estate planning documents? Is a quote for your services provided up front? Yes, always. And how our fees are determined, we work on a flat fee basis for the most part for estate planning. If your estate's really, really complicated, that sort of goes out the window. And what it looks like varies greatly depending on what you need. For an individual who just needs will, power of attorney, advance directive, the fee is probably going to be around 2,000. For a married couple where, let's say they have 2 children, minor children, and we're creating a will, power of attorney, advance directive, trust, retitling their property, our fee typically is about 4,000. That increases each year, but that's generally what it is. And when we have our initial consultation, I talk to you about the fees, and I'm very transparent sort of with what it is. Where it gets more complicated is, for example, one of my clients who I'm chatting with today, she moved here from New York. She asked me to read her documents. I said, sure, no problem. I'll spend an hour of my time, and we can chat about your documents and go from there. And so I gave her a list of recommendations just to get her documents into Virginia law compliance. She then came back, and I gave her one price quote. She then came back to me and said, oh, but I also want to make these 5 changes and add in these beneficiaries and change the trustee. And I'm like, well, that's kind of rewriting your entire document as opposed to just amending it. So, but I try and be totally transparent, tell everyone she's fully aware of that and is good with it. One of the questions someone asked is $18,000 limit gift per person per year, or 18,000 total per year. It is 18,000 per person per year. So you could leave your brother, your sister, your niece, your nephew, your grandchild, your daughter, each $18,000 each year, and that's fine. What does an out-of-state executor need to do in Virginia? So you can name someone as your agent for your power of attorney, advance directive, and your will and your trust, who is outside of Virginia. They just may have to jump through a couple extra hoops. And one of them, with regard to being executor in the will specifically, is they have to post a bond so that basically they don't run away with the value of the assets. It's not that hard to get one. It's typically based on a percentage of the overall assets of the estate, but that is something they have to do. The good news for out-of-state executors, sort of silver lining of COVID, but is for the most part, they don't actually have to ever come to Virginia. They can qualify with an online appointment through Zoom or Teams or any of those, so that they don't actually have to fly back and forth here too often. Any other questions I can answer for anyone? I know we have about 9 minutes left. And what I should say, again, I posted my contact information in the group chat, but also it's in my PowerPoint. I'm going to share my PowerPoint. Feel free to email, call. There's no such thing as a stupid question, particularly estate administration gets so complicated. So even if you have a question, where you're the executor of something, we're happy to help you with the estate administration of that. Just let me know. So Gary, I'll turn it back to you. Oh, someone else posted a question. If you have no immediate family, is it advisable to designate your attorney as your executor? There are many reasons in addition to that people designate attorneys, accountants as executor. I was just chatting with a client this morning who was concerned because they have 4 adult children. They were going to appoint one as the executor and that person as trustee as well. But they were like, there's some sibling squabbling among everyone. And I was like, well, just don't appoint your child, appoint us. We can serve in that role and kind of cut through all that emotion that's there, because we really just go by what the letter of the document is and making sure we get the money out to whomever it is. Someone just asked, on average, how long does it take to complete all the requested documents? Usually what I say is from the time I get your information to flipping drafts to you, that often will have yellow highlights, bubble comments, but sort of set us up to have a discussion, it's typically about 2 weeks. Caveat, of course, is, for example, I'll be in London next week visiting my sister. So if you sent me something Monday next week, it's probably going to be 3 weeks, simply because I'm not working next week, and or at least hoping to not work next week, unless there's an emergency. So someone asked, what do attorneys typically charge to act as an executor? Just our hourly rate. So it really depends. My hourly rate currently is $4.75 an hour. My paralegals are 200 to go all the way through probate. If it's a simple estate, can be 5,000. If it's more complicated, can be 10,000. Um, I'm involved in an estate right now that's been going on for 6 years, and I would guess the fees are more like 100,000. So it really just depends, right? I mean, it's hard to say because we don't know what's going to happen or who's going to squabble or what's going to be complicated about it, which is again why we charge hourly. But I try and get our paralegals to do as much of it as possible where it's not really legal that I need to be doing it, but it's more, oh my gosh, sitting on the phone with Fidelity, trying to get them to convert the account from you into your estate. So thank you very much. I'll turn it back over to Gary and Cheryl.
Okay, it doesn't look like there's any more questions. Wow, you covered a lot of information, Jennifer. That is certainly very helpful, and I'm sure that people will appreciate getting your uh, the information that you did on your PowerPoint so that they can kind of look it over and get in touch. And I think you did put your email address, or is that the best way, or just call your law firm, or how does that work?
So yes, I posted my email address and I posted my phone number. Either are fine. Um, you know, you can always leave a voicemail for me if I don't answer the phone. So email or voicemail are fine, and someone will find me and we'll get back to. My goal always is to respond to people within 24 hours. Again, I mean, out of town, sick, things like that, things happen, but that's generally the goal.
And tell us the address of the law firm, just because maybe since a lot of us are in Arlington here, obviously.
Yes, we are at 2311 Wilson Boulevard. So we're across from the Navy League building and that new Hyatt. We're right by the courthouse metro station. So, and there's free parking under our building, or validated parking, I should say, under our building. So we're easy to get to for people in Arlington is the good
Okay,
news.
sounds good. Okay. Well, again, thank you so much for your presentation. And let's see, yes, we even have 4 extra minutes here. So just a reminder that next week, our guest will be Tom Manganiello. And another kind of business or personal income and thinking about our future and even our present. Tom's going to be talking about never stop learning, invest for the future, and protect your nest egg. So, kind of coincides with what you were talking about today, Jennifer. So, we're getting a lot of really good legal information here over the next couple of weeks. So I just want to remind you again that if you have time and you want to go over to the Thomas Jefferson Community Center, starting on Friday noon and going through Sunday afternoon, you can also go stop by the ANV table and the Aging Matters table, which will be right next door to it, and say hello. And we'll have lots of information there for you. So be sure and stop by and say hello and tell us how much you love ANV. So, and I guess that's it. So, Gary, any final comments that you have, or are we good?
Well, let me stop the recording first.